The first one is a judgment, no? You call the second item, I think it'll be bringing it. Call the second item.
From the supplementary list, item number 2.
Yes, come.
May I please, Your Lordship, my lord.
Please and take it. Yes.
My lord, this appeal is directed against the judgment passed by the single judge on 29/2/24, my lord. My lord, can I place the big fact, my lord? My lord, the FCI, Food Corporation India.
No, where is the order?
My lord, Lordship will find page number 244. 244, my lord.
No, the office note says that some of the pages are not legible. Page number 172, 173.
172 and
On
70.
proper checking of the found that pages 171 to 173 and page number 205 are not legible.
My lord, my lord. My lord, what happened, my lord? Actually, these documents are annexed with the affidavit of opposition by the other side. And from there, we have prostrated. These documents you don't have with me.
You should have typed it and.
My lord, you're right. Your Lordship is absolutely right, my lord. Lordship is right, my lord, because.
You produce a clean copy. We'll call the matter on Monday. We'll call the matter on Monday.
Monday, my lord. Wednesday can it be possible? I've come from Guwahati and some matter fixed before in Guwahati. Wednesday.
When do you want?
Next Thursday, my lord. Next Thursday.
This is April.
Wednesday, my lord. Make it Wednesday.
Wait, 22nd.
22nd, my lord. Yes, my lord.
In order to enable the appellant to furnish clean copy of the pages from 171 to 183 and page number 205,
23.
comma, who's the matter on 22nd April.
My lord, make it 23, my lord.
16th,
23.
23rd.
Yes, my lord.
23rd April.
Authorized, my lord. Actually, we got a notice.
The junior must have seen it.
Actually,
On your card who is interested in instructing you must have seen it.
my lord.
Yes.
Anyway, my lord, just will rectify that.
No problem.
Yes, authorized, my lord.
Item number 1, pronouncement of judgment.
The appellants are not entitled to any relief. Last but not the least, in the concluded matter, miscellaneous application is not maintainable. If the applicants had any doubt about the direction issued by the court, they should have filed a review, seeking the review of the order. Now much water has flown, and the apex court has also confirmed the order of this court, holding that MTET is mandatory. In the light of the judgment reported in 2023 SEC Online 985, the norms prescribed by NCTE have got to be followed, and in terms of section 23(1) of RT Act 2009, a candidate must have cleared MTET for the purpose of considering his or her case for appointment as assistant teacher. In view of the same, the relief sought for by the applicant cannot be granted. Accordingly, MC number so and so is dismissed. Though it is a fit case for imposing costs, taking note of the fact that the applicants are seeking for employment, this court refrained from imposing any costs.
Item number 3.
May it please your Lordship. Lordship, I pray for 1 week time, Lordship. Due to some personal difficulties, the arguing counsel could not come, Lordship.
Person Khalil, what is the matter about?
It's matter about, Lordship, is dismissal from the service, Lordship. Actually, the
Dismiss for service.
yes, Lordship.
Yes.
Actually, Lordship, the fact was that it is they said that it was the allegation that I have shoot one my fellow staff. Then fellow,
Abused.
yes,
Abused the fellow staff.
He shot at him.
I shot.
Shot.
Yes, yes.
He is in Assam Rifle, my lord, the appellant.
And then there,
And he shot at one of his fellow constables, my lord, injuring him in his knee. And so he was court-martialed, my lord, and he was dismissed from service. He's come against that.
Who do you expect you to give a job? Dismiss it.
Lordship, I pray for time, Lordship.
Why? It's
Lordship,
coming up for admission.
Lordship, the arguing
So whether it should be admitted or not, it is between the court and you. And we have, see, this is not a case. There is a case of absence and other things you can understand. Three shots, service weapon. Thereby wounded his right knee, neck and lower abdomen.
Lordship, we are raising here, Lordship, some legal flaws, Lordship, which was
What is the point in your favor? Legal point in your favor. What is the lacuna in the inquiry?
Lordship, I'm not, Lordship, if it's possible, let this matter come after 1 week, Lordship.
Huh?
I'm not the arguing counsel, Lordship, that's why.
It cannot be. You are an instructing counsel. Instructing counsel must be in a position to argue.
Lordship,
If you go to an operation theatre,
Lordship,
senior doctor will be there, junior doctor will be there. If the senior doctor is not able to perform, the junior doctor will continue to perform the operation. Otherwise, the patient will die.
He's taking the plea of lunacy, my lord.
Huh?
He's saying that he was lunatic.
And more, then it's more dangerous. Sorry. We'll dismiss it.
Lordship, let this matter come after 1 week, Lordship. My humble prayer, let this matter come after 1 week, Lordship.
No case, sir. No case. Where is the order of single judge?
The judgment is at page 75, Annex 3, Lordship.
70?
75.
75. See, even assuming that the statutory limitation can be condoned, there is no perversity in the finding of the inquiry officer. And you have also been sentenced to imprisonment. You are not preferred an appeal within 3 months. Where is the plea that he has taken that he is lunatic?
In the appeal, he has taken that plea, my lord. In the appeal,
Not earlier.
he did not argue this point before the learned single judge, my lord. In the appeal papers, my lord, to kindly see
Page number?
page 13, my lord.
1-3.
Page 13, ground number 6.
Ground number 6, my lord.
Even assuming that the incident can be condoned with regard of shooting 3 times at a person. Since you are lunatic, how can you be allowed to continue to work? On that score, also you will not go out. Dismiss it. We'll dismiss it, sorry.
Lordship, my humble praise, let this matter come after 1 week, Lordship.
When is it going to come?
Lordship,
Monday,
if it is possible, let this matter come on 9th April, Lordship.
not on 9th, 8th.
Because the appellant counsel is in personal difficulties. So he said that
You read and come, you read and argue the matter, that's all. We have read the papers, we are thorough. Monday,
Lordship, kindly on Tuesday, Lordship. Kindly on Tuesday.
Tuesday is not possible, Monday.
Any other day, Lordship, except Tuesday or
We have it on Monday. Monday you argue. Post orders, see, circulate the file.
From the main list, item number 1.
See, we make it very clear. If you don't come, we will pronounce orders. Stating that we heard you and we pronounce orders. Yes.
My lord. Item number 1. My lord, this is appeal filed by the department, revenue department, my lord. My lord, it is not maintainable because no substantial question of law involved in this matter, my lord.
Yes.
But here I am the appellant, my lord. But we have come against the order passed by the Central Excise and Customs Appellate Tribunal, my lord. The matter pertains to seizure of gold, my lord.
Seizure of gold.
Gold, my lord. And the learned trial court has exonerated them, my lord. And I was praying for some time, my lord, today, because the matter I could not prepare yesterday.
On time.
Some time, my lord.
The request of the appellant. What's the matter? On 29th.
Oblige, my lord.
Item number 2.
This is the PR, my lord, against the respondent, my lord, for particularly respondent number 7, my lord, for siphoning and defalcation of public funds, my lord, in the name of
Sir?
procuring. But this is a PRL, my lord. PRL petition directed against the respondent, my lord.
With regard to, they said they are going to fix an inquiry. What happened to the inquiry?
Lordship, inquiry is still going on, Lordship, and next day, so can I produce the latest order, Lordship?
Yes.
Lordship, as per the last order, it was stated that both the presenting officer and the charge officer were present, and from the police headquarters.
Reinstated open to the department to proceed in the court of law. Yes.
Lordship, as per right now, is for producing of the documents.
30th April.
Yes, Lordship.
We're not going to finish it. See, you're adjourning the inquiry by 1 month.
Lordship, due to the election, which is upcoming elections,
What is this? The election has got to do with this.
Lordship, as per what stated, Lordship, since
So everything I cannot say election. Election, then the results is going to come only in the month of June, June 3rd. Then till June 3rd, you will not do any progress.
no, Lordship, so right now the elections are on 19th, so after 19th,
In this state is 19th. In different state, different dates.
Lordship.
And you have fixed it at 19th the election, 30th April you have fixed it. It is represented today. The respondent have produced an order sheet dated 26/3/2024, postponing the inquiry to 30th April 2024. Full stop. Respondent is expected to file the status report on the next date of hearing with regard to progress of the inquiry. All the matter on Monday, 1st May is the date, 6th May. 6th May.
Obliged.
I do oblige.
In the case the person was incarcerated and all those things, this is the case, you know.
That's the case.
Huh?
That's the case. That was a plain.
You also reinstated him.
Lordship, right now the criminal proceedings are have been initiated against him, and 6 out of the 7, if I'm not mistaken, 6 out of the 7.
Is he under suspension?
Lordship,
Is he under suspension?
Lordship,
You have not reinstated him.
no, Lordship.
Then,
DP,
how long the criminal case is pending?
Lordship, as per right now, out of the 7, 6 have been charge sheeted and
How long, when was the charge sheet?
charge sheeted.
See, last time also, since it's the PAL, we are not in a position to do anything. The person concerned can approach this court, saying that you have not completed the inquiry within 1 year.
Lordship. Lordship,
Supreme Court in 2 or 3 judgments have held that if you don't complete it, then you post him in a non-sensitive post.
Lordship.
You will be paying 75% of your wages without extracting work. And you are also not showing any interest in proceeding with the inquiry.
Lordship, as per my instructions, Lordship, the inquiry is going in right earnest, Lordship.
Whether it's going in the right direction or not, we don't know. But you cannot be adjourning the matter by a month or so. Yes.
Much obliged.
Item number 3.
May it please your lordships, I appear for the respondent, my lords. There's an appeal by the revenue against the tribunal's order, my lords. Lords, we have a preliminary objection that the appeal doesn't lie before this court because this is an issue relating to valuation. This has to go to the apex court. In fact, the tribunal follows the judgment of the tribunal which has been affirmed by apex court. The revenue had challenged that order before the apex court and the apex court dismissed the revenue's appeal.
What is it, miscellaneous petition?
Well, there is a delay.
The delay in filing the appeal before your lordships, my lord. My lords, our supplement
delay?
45 days.
it's about 45 days, my lords.
45 days.
Yes, my lords.
Only 45 days.
Only 45.
We'll condone the delay and take up the matter and then we pass orders.
I have no difficulty as far as the delay is concerned, my lords, but the appeal is not maintainable before your lordships, my lord. This has to go to Supreme Court.
But we'll consider. In fact, last time also one case was argued before this court and not under, is it under the Central Excise Act?
Yes, my lord. It's under the Central Excise Act. Section 35G of the Central Excise Act says the appeal to the High Court.
My lord, that was, we came by way of a review, my lord. After taking leave from the Honorable Supreme Court, your lordship held that the review is not maintainable because there is a statutory appeal to Supreme Court under the Central Excise Act.
Under 35L, there is a statutory appeal to the Supreme
The
Court.
same act. Same act.
Same, exactly. Same.
Subject to correction, that is an order passed by my brother sitting singly, which we have affirmed. I think sitting with Justice Bhattacharya, I think I passed an order. Confirming my brother's order. Not yet. You passes the- Some order was passed, I think with my, sitting with my brother. I don't know.
Well, bench,
But you would not have taken up by way of single because it will go before
This has to go before the division bench. Your lordships are right. The appeal will lie before a division bench of the High Court under 35G only on questions not relating
These
to.
are together, and I think the matter was originally heard by Justice Sanjeev Banerjee and Justice Bhattacharya.
Justice, thank you, my lord.
Huh?
Justice, thank you.
Or maybe.
Yes, my lord.
So I think I sat with him and passed orders.
My lord. My lord.
Where is the order? I think we passed orders.
But the issue is different, my lord. The issue here is
May I just
different. my lord.
permit that?
1 minute.
My apology. My apologies.
The issue here is different, my lord. Because there what happened, my lord, we went to Supreme Court against the order passed by Justice Banerjee, Chief Justice Banerjee and Justice Sankyu. So we took leave from the Honorable Supreme Court to file a review before this Honorable Court, my lord. Then we filed a review. Objection was raised that there is no provision of review under the Central Excise Act. And in fact,
Here against the order of the division bench,
There is no
only
appeal.
the Supreme Court,
my lord,
we can approach only the Supreme Court.
my lord.
So can you get the copy of the order?
Lordship, may kindly see para 10 of the impugn order of the tribunal. I will not say anything further beyond this. Page 4 of the revenues appeal. Internal page 4. Internal page 4 of the tribunal.
Page?
Internal page number 4 of the tribunal's order. The revenue has annexed in their appeal as first exhibit itself, my lords. This is an order dated 23rd of June 2023.
1 minute, sir.
My apology, my lords. Your lordships have the tribunal's order, my lord.
This tribunal's order, Calcutta.
Calcutta, my lords. Lordships may kindly come to internal page 4, para 10. That is where the tribunal starts its findings.
Yes.
Heard both sides peruse appeal record. The issue to be decided in this case is whether the appellant has provided consulting engineer service as defined under 6531 of the Finance Act to the client. If yes, what shall be the value of such service provided? This question of valuation goes to Supreme Court because 35G says anything other than classification and valuation can come to the High Court provided it's a substantial question of law. We have other submission also that's a pure finding of fact. I'll show the entire tribunal order, my lords. It's a pure finding of fact. No question of law is involved. Be that as it may, this appeal lies to Supreme Court and I'll tell your lordships why they have come here. I will tell you that also, lordships. Because to file an appeal, lordship, they have their internal circular that if the amount involved is less than 2 crores, they will not go to Supreme Court. That is why they file appeal before your lordships because they will
Not be here.
I'm telling you, lordships. I'm telling because I circular, I'll send out a circular. Why they file appeal here with delays? Because the limit to file appeal to the High Court is 1 crore. And the amount is less than 2 crores because they cannot go to Supreme Court. That is why they filed appeal here, lords.
That's not correct, my lord. My lord, what I pray, my lord, today,
We'll condone the delay.
No difficulty as far as delay is concerned. I will not.
Delay being condoned. Delay is condoned. Registry is directed to number the appeal. On list for hearing. Where do you want? 29th?
29th or 30th minute, subject to.
Lords, can it be any Friday, my lords? My apology. Any Friday, Thursday, Friday, my lords? Monday, Tuesday becomes difficult for me, my lords.
Wednesday?
Wednesday should be okay, my lords.
First.
1st of May.
1st of May, my lords. Perfect. 1st of May would be fine, my lords. Because in the meantime, we'll just file a short synopsis on that, along with the judgments of the Supreme Court and your Lordship judgment, identically on this point itself, my Lordship.
Yes.
Lordship, please. Great. We'll file it, my Lordship.
Yes.
Lordship, please. Great.
In the file, this file also is sent. This file also is sent.
From supplementary list, item number 1 from announcement of order.
Only case. Eh? Only case. 2 more. Similar case, and I think I've considered and granted relief. Is it not?
Yes, sir.
You refer to it here. of 2019. Where it's a nurse case. You know, doctors and nurses with sight. Is that case, you know? Eyesight.
Malad, this is with regard to hearing.
Yes. Here you're suffering from tuberculosis. Hearing problem, yes. Hearing problem. The petitioner is not entitled to any relief. This petition is dismissed.
Deeply.
Lordship.
From the daily list, item number 1.
Yes.
My lord, in this petition, the matter has been part heard by the other bench, my lord, and we have already filed our written argument, my lord.
What would your response? Last time you have taken time.
But I'm ready, my lord. If they start, I can argument. Well, here what happened, my lord?
What is the matter about?
Well, here, my lord, the petitioner and many others, my lord, in Assam Rifles, service reviews carried out after completion in Assam Rifles, my lord, in terms of Rule 56J of the CCS rules, my lord, service reviews carried out after completion of 30 years of service to see whether he is fit to be further retained in service or not, my lord. So, my lord, in the year 2015-16, when the service review was carried out, my lord, it was found that the petitioner was not.
But you said that you will file a response. Where is your response? Last time. This is what we have recorded. You must give, unless you give the gist, I will not be in a position to go.
I can give it just, my lord. But the matter is very simple matter, my lord. I only need to refer 2-3 orders, my lord.
For two?
2-3 orders passed by this moment.
Yes. What is the issue involved in this case?
But the issue is, my lord, they were not keeping medically fit, my lord. They are serving in Assam Rifles, my lord. So, because they were physically unfit, my lord, service review was carried out on after they completed 30 years of service. And it
30
was
years.
30 years of service, my lord. What happens, my lord? Some become obese, my lord, overweight. Some suffer from diabetes. Some suffer from blood pressure and all those things, my lord. So, under the rules, my lord, they can be retired compulsorily with all service benefits, my lord.
Compulsory retired?
From service by giving them all retirement benefits, including pension and provident fund and whatever they are entitled to, my lord. So, my lord, in the year 2015-16, an similar exercise was carried out by Assam Rifle, my lord, and about 80 or 90 of the soldiers, my lord, in Assam Rifles were declared medically unfit and they were discharged from service, my lord. They came before this honorable court, my lord, saying that compulsory retirement under the rules is only for consideration of ACR and other things, my lord. If their ACR is not correct, on medical grounds, somebody cannot be retired under 48(1)(b) and 56(j), my lord. They cannot be compulsory retired under for medical grounds, my lord. This honorable court upheld the discharge, my lord. The learned single judge of this honorable court. The matter went to appeal, my lord. If I may draw your lordship's attention to the orders passed by this honorable court, my lord.
96.
My lordship kindly sees, my lord, the first order passed by the learned single judge. It starts from page 22, my lord.
Yes.
My lord, a batch of many writ petitions, my lord, was disposed of by this common order, and the operative party lordship will find that
Yes.
at page 90, my lord.
Yes.
I'll read para 11, my lord. The submissions advanced by the learned counsel is that if they are allowed to continue to do more service, they will be benefited by the 7 pay commission pay structure and they'll get their regular salaries, which in my view has no relevancy when they were found to be medically unfit. We must remember that the national interest as well as public interest is much higher than individual interest. I cannot allow to keep deadwood employees and thereby weakening the forces. For the reasons discussed above, after giving my consensus thought and on perusal of the petitions, counter affidavits, etc., I do not find anything wrong on the part of the respondent to decide an order for compulsory retirement of the petitioners, taking into account their medical condition and nature of service. So I did not find any scope to record reasons to interfere with the decision of the respondent's authority by this. So accordingly, their writ petitions were dismissed, my lord. So my lord will notice, my lord, in the present writ petition, my lord, there were 60 or 70 petitioners, my lord. The court title will reveal.
Yes.
Now, my lord, against this order of the learned single judge, only some of them, they preferred a writ appeal before this honorable court, my lord. My lord, that order starts from page 95.
Yes.
So, my lord, only 21 petitioners, my lord, they preferred the appeal. The remaining 60 or 70, they did not prefer an appeal. The writ appellant before lordship now, he did not prefer the appeal, my lord, at that point of time. Now, what learned division bench held, my lord, lordship will see that at page 111, my lord.
Yes.
Conclusion, my lord, towards the bottom. Accordingly, and in view of the above, these appeals stand allowed to the extent indicated. The impugned orders qua the petitioner's appellants are set aside and related writ petitions stand restored for reconsideration of the learned single judge. So, my lord, only 21 writ petitions were restored, my lord. Petitioner never filed his appeal. He was not the appellant at that point of time, my lord. So, our case is, my
He
lord,
has already approached this court.
he filed only writ petition, my lord. His writ petition was dismissed. He did not file any appeal.
He's almost res judicata.
My lord, that is our case, my lord. It is because only relief was granted to 21 petitioners, my lord. He is not one of them.
What is the WP number? His earlier WP number?
My lord, your lordship will see in this petition there are 8 writ petitioners, my lord.
What is the writ petition? His writ petition number? Or one of the writ petitioners?
WPC number 59,
59 of?
2015.
Dismissed on?
My lord, dismissed on 15/3/2016.
Dated?
15th March 2016.
Ah,
Division bench order, my lord,
yes, 111.
is
So
111.
let's say, what happened to the subsequent reconsideration? What happened?
My lord, after reconsideration, my lord, they succeeded in the writ petition, my lord. That your lordship will find at Does not annex that. The stating those order.
So we got on remand 22 petitioners.
My lord. My lord, our case is that they are covered by res judicata, my lord. They cannot hesitate, and especially they were dismissed in 2015, my lord. They filed the present writ petition in 2021 after 6 years.
2016 dismissed.
2015, 2015.
15/3/2016 you said?
That is the order of the learned single judge, my lord.
Oh, that's what. He's also a party to that, order.
My lord, he was dismissed from 7. He was dismissed,
59 of 2012.
my lord.
That was dismissed on 15/3/2016.
My lord.
The present writ petitioner was also a party to that writ petition.
My lord.
So 2016, writ petition, now to 2021, they filed an appeal, a writ petition again.
Again, a writ petition, my lord.
Writ petition again.
My lord.
For the same relief.
For the same relief, my lord.
Yes.
So that is our case, my lord.
Yes, sir. Yes, counsel.
My lord, I had already actually placed my arguments before the other bench. Written argument is also submitted. Today, my lord, the matter has suddenly come up. All the papers
Not
are not with
suddenly.
me. my
It's
lord.
already there on the list. It came up and I think the date was fixed by me, subject to correction. Is it not? How do you? It's not though.
It was fixed for filing of written arguments by the
1
central
minute, sir.
government.
1 minute. 1 minute.
My lord.
So the matter came up before Ding Dong on 23.
My lord.
So anyone who learned single judges posted the matter after 1 week. Now it has come up.
My lord. In fact, my arguments were concluded, my lord, before the learned single judge, my lord.
Oh, you have not
The other
argued
day.
before me.
My lord, I have not. I have not. Today, my lord, I was not prepared that, my lord, it would be reheard, my lord, in this manner. But then our
according to
substance, my
according
lord,
to
was
the
there.
parted matter.
It's not parted, my lord. There is no order to that effect.
Has to be, my lord, because it is not recorded or written
If
as
they are
part
requesting
of
for
my
time, my lord, the matter may come up after 1 week or 10 days, my lord.
Yes.
my lord.
The counsel appealing for the petitioner submitted that he has addressed the argument before the learned single judge, the other bench. And stated that he filed a summary of argument and that Dr. Mosika sought time and the learned single judge granted a week's time on 23/2024. Further submit that you would like to place his submissions before the bench. The counsel appearing with the Mr. Mosika, Dr. Mosika, submitted that writ petitioner has approached this court earlier, and he was one of the writ petitioners in WP 59 of 2012, and the batch of writ petition got dismissed on 15/3/2016. There were several writ petitioners, and only 21 persons have filed writ appeal, and the order of the learned single judge was interfered with, and writ petition was restored to 5. Insofar as the present petitioner is concerned, the order has become final, and that after a delay of 5 years, the petitioner has approached this court for the same relief, which is hit by res judicata. In order to hear the writ petition, and further submission of Dr. Mosika, post the matter after 2 weeks. Date, we'll fix a date. In the meantime, you also, if you have any
My lord.
submission, you will give the submission to the other side.
My lord.
Item number 2.
Deeply obliged.
That's all. Last item.
With please, Your Lordship.
Oh, this also came up before another judge.
Yes, Your Lordship. So, Your Lordship, the matter involved here is that the petitioner here was.
What is the matter about?
The matter is about termination, Your Lordship.
Termination.
Yes, from service. He is a teacher before the respondent school. Your Lordship, at first instance, he was terminated on 16/12/2015. Your Lordship, which is at page 26 of my petition.
So I'll go through the paper and hear it on Monday.
My lord, yes.
I'll read the papers.
My lord.
Come,
Yes, my
Okay, yes, sir.
Monday. Is there any matter on Monday? How many singles? Is it? If there are more cases,
There's 2 matters.
2 matters. We can hear.
Monday, my lord.
Monday.
Coming on Monday, next
Yes.
month, my lord.